Thank you everyone for your patience and for joining us today. This is the Stanford Constitutional Law Center hosting an event today about the second impeachment trial of Donald J. Trump. And I'm delighted to share that we're joined by three wonderful professors at the law school who'll be speaking in the following order. First, Professor Michael McConnell, the director of the Constitutional Law Center and one of our professors of law. He's also a senior fellow at the Hoover Institution, formerly was a judge on the 10th Circuit, and teaches on a variety of topics: constitutional law history, First Amendment, and interpretive theory. Second, we're joined by Professor David Sklansky, who's the co-director of the Stanford Criminal Justice Center. He teaches and writes about criminal law and procedure, as well as evidence. And finally, we're joined by Bernadette Meyler, Bernie Meyler, who is also a professor by courtesy in English and an associate dean for research and intellectual life. She's a scholar of British and American constitutional law and of the law and humanities. And with that, I will turn it over to Michael to begin our remarks.
Thanks, Morgan, and thanks to everyone for coming this evening, and welcome. I'm going to talk about the phenomenon of impeaching and having a trial on the impeachment of a former officer. There are three. This is actually a very interesting constitutional question. I got an email from a student from about 20 years ago reminding me that I put this on the con law exam back, long ago. Just something I've completely forgotten. And there are highly respected scholars on all three of the possible positions on this, and many of them a bit surprising. Like Philip Bobbitt is one of the people who's argued that this impeachment proceeding was not constitutional, and that certainly goes against his politics. So let me lay out the three positions and then argue for the one that I think is most persuasive. One position is that former officers may neither be impeached nor may they be subjected to a trial on the impeachment. The basic argument from this is that the only provision of the Constitution that actually specifies who can be impeached is Article 2, Section 4, and it refers to the president, vice president, and all other civil officers of the United States, and it refers to their being removed from office on impeachment and conviction. Obviously, former officers cannot be removed, and they don't seem to fall within the categories of president, vice president, and other civil officers. So that, and they add to this functional arguments such as, well, if you can impeach a former officer, what's to keep Congress from impeaching private citizens or going back in time and harassing officers from some considerable time ago? So that's one position. A second position is that a former officer can be impeached, and that a former officer can be, that trial can also be held on that impeachment. And the argument here is that there's nothing in the Constitution that specifically precludes that, and there is at least some precedent for impeaching former officers. There's also a fairly powerful functional argument in support of that position, namely that otherwise officers who commit heinous abuses of power in the final days of their term would basically not be subject to sanctions under the impeachment proceedings. Now, the third position, which is the one that I have put forward in print in various places, in which the House managers seem to move toward during the course of their argument, is that former officers cannot be impeached, but once there is an impeachment of a sitting officer, that the Senate is empowered to try that impeachment. And The argument here is that is a little similar to the first, in that the president, vice president, and other civil officers does appear to refer to current officers. I think that must be a provision of restriction, because otherwise, I do think, what is to prevent impeaching private citizens? What is to prevent impeaching military officers? And what is to prevent impeaching members of Congress who are not civil officers? Each of those things is, I think, unthinkable or unconstitutional. And unless we read this clause as a restriction, there's nothing else in the Constitution to protect us from those results. But it doesn't have anything to do with this particular impeachment, because Donald Trump was still president on the day that he was impeached by the House of Representatives. He was impeached on January 13th, which was about a week before his term came to an end. So his impeachment was entirely unobjectionable. It raises no questions of timing whatsoever. And then Article 1 provides that the Senate has sole power to try, and it says all impeachments. And I think the most logical interpretation of that provision is that it means all impeachments. That is, yes, there's a restriction for whom the House can impeach, but as long as the House has properly done what it should, and it is a proper impeachment, that the Senate then has the authority to carry on the trial. And of course, at the end, if the person is convicted, the Constitution requires the removal of the sitting officer. There's no discretion with respect to that. Mandatory sanction of removal, and then, but it gives a discretionary sanction of disqualification from future office, so that if an officer is impeached but is out of office by the time that the Senate convicts, I believe that the Senate may impose the sanction of disqualification from future office. I'm done.
Morgan, you want me to go ahead?
David?
All right. So Morgan asked me to talk about incitement. So I'm going to talk about three questions. Did the article of impeachment passed by the House on January 11th set out an impeachable offense? Now that Trump was acquitted in the Senate, can he be prosecuted and convicted for criminal incitement? And three, could he be barred under Section 3 of the 14th Amendment from running for public office in the future because he's engaged in insurrection? And my answers are going to be yes to the first question, unlikely to the second question, and very unlikely to the third question. So the background here is that the articles of impeachment on January 11th, actually there was just one article of impeachment. It was entitled Incitement of Insurrection, and it charged Trump with inciting violence against the government of the United States by first repeatedly asserting falsely that there had been widespread fraud in last November's election and that therefore the results shouldn't be accepted. And second, then on January 2nd, making incendiary statements to the crowd on the ellipse that in context encouraged and foreseeably resulted in lawless action at the Capitol. So the standard for impeachment, most people agree, is, well, everybody agrees the requirement is high crimes and misdemeanor because that's what the Constitution says. I think there's generally been a bipartisan consensus over the last 50 years that high crimes and misdemeanors don't have to be a crime that's prosecutable in an ordinary criminal court. High crimes and misdemeanors is a term of art that means a serious abuse of power. And my own view is that it's hard to imagine a more serious abuse of power than what these articles of impeachment charge the president with doing. Was it criminal incitement? That's a much harder question to answer affirmatively, because the Supreme Court has required that under the First Amendment that statements that are the basis for a criminal incitement conviction be calculated to produce imminent violence. Now, in context, that may be true of what Trump did, but the Supreme Court has interpreted its test very strictly. It's generally said that the words have to call pretty clearly and explicitly for illegal violence. And in this respect, I think it's helpful to compare Trump with a guy named Arthur Terminiello, who was an anti-Semitic demagogue in the 1940s, and actually comparably odious to Donald Trump. He traveled around the country denouncing Jews and demanding that those who had led the United States into World War II be hung as traitors. After President Roosevelt died, Terminiello speculated that Roosevelt might still be alive. He said, some people don't think he's dead. Some people think he's in Palestine. So as you can see, he was a kind of proto-Trumpian figure. And the speech that wound up taking him to the Supreme Court was given before 1,500 supporters in Chicago in 1946. There's a crowd of hundreds of anti-fascist protesters gathered outside the auditorium, and Terminiello egged on his supporters inside the hall, told them that the people outside were trying to destroy America by revolution. He said, we're going to walk out of here dignified. We're going to stand up and dare them to smear us. We're not going to lock ourselves in an upper room for fear of the Jews, because we don't want them here. We want them to go back where they came from. But he didn't actually call for violence. He said they should walk out of there dignified. So predictably, fighting broke out. Terminiello was arrested, charged with a breach of the peace, convicted by a jury, and fined $100. And the Supreme Court reversed on a 5-4 vote because under the First Amendment, speech can only be criminalized if it created a clear and present danger of a serious substantive evil, and it wasn't clear that the jury had been properly instructed that they needed to find that in this case. And the Supreme Court suggested that even with proper instructions, it wasn't clear that that standard had been satisfied. So the longest dissent in the case was by Justice Robert Jackson, who had recently returned from serving as the chief American prosecutor at the Nuremberg trials. And he pointed out that Terminiello's speech had followed the classic pattern of European fascist leaders. And he argued that you needed to analyze speech in context because, he said, the Bill of Rights shouldn't be turned into a suicide pact. You've all heard of that last line, but you need to remember this was a dissent. His approach to the First Amendment, to incendiary words, was rejected by the Supreme Court. And today, the Terminiello case it's not, nobody cites it to say, the Supreme Court was really wrong. They should have done what Jackson said. No, this is viewed as a great application of the First Amendment. And it may well have been a great application of the First Amendment because there's a longstanding idea that democracy thrives when all ideas can be expressed, even ideas that get people really, really angry. And it's not clear that Trump's words on January 6th, his call to fight much harder, his warning that the country couldn't be won back with weakness, called for violence explicitly enough to cross the line into criminal incitement if he was a private citizen. But he's not a private citizen. He's the president, and the standard for impeachment is appropriately different than the standard for criminal incitement. Third question, what about now that he's been acquitted, can he be barred from running for office in the future because Section 3 of the 14th Amendment says that any executive officer who engages in insurrection or rebellion against the United States is barred from future federal office. And Congress is given the power in Section 5 of the 14th Amendment to enforce by appropriate legislation the other provisions of the article. So a number of people suggested, well, we can use this now. All you need is Congress to pass a law by a majority vote saying that Trump violated Section 3 and can't be president anymore. I don't think so. So there are three big problems here. First, it's not clear how Section 3 is supposed to be enforced. If Congress passes a law singling out the president, there's a serious argument that that's a bill of attainder. It's also unclear how you would get a court to rule if Congress doesn't pass a law. So there's this procedural problem. Second, saying that Trump engaged in insurrection is saying a lot more than saying that he engaged in a high crime or misdemeanor. So it's not clear to me on the merits that his conduct satisfies the requirements for applying Article 3. And finally, there's an argument that he may not even be an executive officer within the meaning of Section 3. That doesn't move me as much as the first two, but the first two are reason enough, I think, to not to hold out hope that he's going to be barred from office under Section 3 of the 14th Amendment. That's it.
Great. So I feel like most of the points have been covered. So I just want to touch on a couple of things. And the main point I want to emphasize is just the difference between impeachment proceedings and other kinds of tribunals. And I think that that's going to be really relevant in how we think about both Trump's first and second impeachment. And then also, I'll just make a small point at the end, saying that I have a slightly different perspective on the Section 3 of the 14th Amendment question than David, although I agree that it's an implausible route to go down. So I want to emphasize kind of 2 points about impeachment as a special kind of proceeding. So first of all, as David was discussing, there's a different standard that's applied to regular criminal conduct and impeachable offenses. So incitement in the impeachment context doesn't have to be the same as incitement in the context of criminal law. And this issue also arose in Trump's first impeachment trial in terms of whether he needed to be charged with something that actually was a federal offense or an offense under federal law, or whether high crimes and misdemeanors could be a more comprehensive designation. So I think that it's important to really insist on the difference substantively and procedurally between impeachment proceedings and regular criminal trials. And of course, on the procedural front, the Supreme Court has kind of weighed in and said that there's much more flexibility with regard to what it means to try a case in the impeachment context than in the criminal context, because the Senate is given the power to try impeachments. That means they can define some of the terms of what it means to try an impeachment. Now, I think there's another really fundamental issue with impeachments, which is that there's this standard that 2/3 of the senators have to vote to convict. Now, I think that history teaches us that that means that most impeachments will not receive convictions. There are a number of people who have left office or resigned after being impeached, but haven't necessarily been convicted. And I would just emphasize that fewer than 10 people have ever been convicted on an impeachment in the course of constitutional history. And that includes all the officers. No president has been convicted on an impeachment. There have been a couple of judges and others, but fewer than 10 in the whole history of the Constitution. So that really means that impeachment isn't going to work as a check on misbehavior in the executive branch or in other branches. So one question that I think is worth thinking about is, what are the functions of impeachment aside from attempting to secure a conviction? Is there some kind of expressive function of an impeachment, even apart from the possibility that the person impeached is going to be convicted? And I think that that question is really raised in an interesting way by both of the impeachment trials of Trump. Maybe there was more plausibility the second time around that the Senate would have voted to convict, but I think that in both contexts, it seemed unlikely that the Senate would convict. So there's a question of what does it mean then to impeach a president when conviction is unlikely? What kind of function does that have? Is it helping to establish certain kinds of facts, or is it helping to express a view? So I think that that's maybe an open question and an interesting one. And then finally, just on the point that David was raising about Section 3 of the 14th Amendment, certainly I think that saying that the president was engaged in insurrection, that would be difficult to do. Then there is a clause though that says given aid or comfort to the enemies thereof, right? So that's looser language. It's obviously supposed to be in the context of war, but maybe rebellion could also, or some form of insurrection short of war could suffice there. And I think that section is just very interesting because there are ways in which it probably would be disadvantageous to every political party to deploy it, because once it was reactivated, it could be used more broadly against different actors, regardless of the party. But I think it's an important provision because it actually is kind of an exception to bills of attainder, I think. And I think that it was an exception within the context of Reconstruction, where in fact there was a desire to ensure that members of the Confederacy weren't getting back into power. And there's a way in which there was a very kind of personal struggle between sides in that context. And I think Section 3 of the 14th Amendment maybe sits a little bit ill with some other provisions of the Constitution, but comes out of a very particular context of Reconstruction, where there was a feeling that, kind of going back to the Constitution as normal wouldn't be sufficient to mend the nation. So I think that that provision, maybe technically could be used. It probably wouldn't be a good idea for anyone to use it. But I think also I'm glad that people have kind of alighted on that a little bit more, because it shows that the 14th Amendment wasn't just a document about equal protection and due process, but was also this component of Reconstruction and of restorative justice as well. And I think, and transitional justice. Cynthia Nicoletti, a historian, is doing a really interesting book about kind of the other parts of the 14th Amendment, and other people have been kind of working on that. But I think it's an important thing to kind of remember about the 14th Amendment. So I'll leave it there.
Great. Thank you to our three panelists. And we have tons of questions. And so I'm going to dive in and try to give voice to our audience's questions for all of you. Sort of picking up on what Bernie was alluding to, that impeachment might not be an actually meaningful check on a president's behavior in a legal sense. It may have other sorts of functions, but it might not actually have any effect. So one audience member asks, so if impeachment's not going to work, and if criminal incitement is not available to charge him, could Trump be charged with conspiracy to interfere with Congress counting the electoral votes, which is something it's obligated to do under the Constitution?
I'll take that one as a former federal prosecutor. Sure, yeah, he could be. I think the more likely scenario is that he'll get charged by the state of Georgia, well, by the district attorney for Fulton County, Georgia, who has an open investigation for election fraud in Georgia, centering around Trump's efforts to get election officials there to find votes that would reverse the results.
Thanks, David. We have a couple of questions that go to the question of whether or not the impeachment itself was constitutional. A couple of our audience members have asked if you guys could address Article 1's requirement that in any trial of the president, the Chief Justice, quote, shall preside, and in particular, what we should make of the fact that this impeachment trial didn't comply with that requirement. One audience member asks us whether Justice Roberts' the chief's refusal to do this is an indication that he viewed this as unconstitutional. I would imagine you would hesitate to read his mind, but nonetheless, perhaps you have thoughts on the textual question.
I just don't get this textual argument. At the time when the trial was taking place, Trump was not president of the United States, and therefore the Chief Justice need not preside. I don't understand why anyone is concerned about that.
Okay, I'll toss another textual question your direction. Another audience member asks, points to an op-ed that Alan Dershowitz wrote in the Wall Street Journal that says that the Article 2 language ties barring from office to removal. And if removal is no longer possible, is the alternative remedy, the barring from office remedy, is that available?
So I recommend to Professor Dershowitz, as I do to everyone else, to look at the actual wording of the Constitution rather than to paraphrase. And what it says is, judgment in cases of impeachment shall not extend further than to removal from office and disqualification. So when it says that something can't extend further than two things, that does not say that you have to do both. Now, it is true that for sitting officers, they must be, if they're convicted, they must be removed. But for people who are no longer sitting officers, there's nothing in this. He would not be, the judgment would not extend further than both if only one of the two available sanctions is applicable.
I just want to chime in because I completely agree with what Michael is saying here. And I think that, it's really important to understand the context of that language in Article 2, which comes out of the earlier forms of impeachment, which all basically extended to executing the person or removing all of their property and inheritable goods. So the clause, I think, should rightly be read as a limitation on what kinds of sanctions can operate and how impeachment will function within the United States as opposed to in the English context.
So I'll just add, I think that the way that Michael and Bernie have read that language is the most natural way to read the language. I think that it would be permissible to read the language in the way Dershowitz suggests, because I don't think the language is crystal clear. So I think it would be permissible to read it the way Dershowitz suggests, if for functional reasons that made much better sense of the Constitution. But in fact, functionally, that reading doesn't make sense at all. So you have the Dershowitz reading is both it's not the most natural reading of the language, exactly for the reasons that Michael and Bernie say, and it also is it makes the language work in nonsensical ways.
Great, thank you, all three of you, for weighing in on that. Back to the question of whether, if we don't have impeachment as a check, if there might be other ways that Trump could be held legally accountable. An audience member asks if he could be charged for causing the death of the 5 people who died on January 6th.
So I'm the criminal law professor here. Yeah, he could be, but it's unlikely he will be, because it's highly unlikely that he would wind up being convicted of that. The problem is that for a criminal conviction for homicide, you need to show a culpable mental state. And even for criminal negligence, you need to show more than ordinary civil negligence. You need to show some kind of gross negligence. And there is an argument that his conduct was grossly negligent. But I think it's a stretch. And then you'd also need to deal with a First Amendment concern. So I think the odds of him getting charged without offense are quite low.
Well, David, you mentioned the First Amendment, and some of our audience members are curious if you guys could weigh in on the former president's First Amendment defenses, the merits of them, and so forth.
I find them quite unpersuasive, because again, we're talking about impeachment and removal. We're not talking about criminal prosecution. And so the question is whether the president used the powers of his office to either generate violence, or, I think more importantly, to subvert the election recognition. And I also think the dereliction of duty involved in his not acting in this during the several hours that the riot was going on is impeachable. But all of that involves words. I don't think we want to say that presidents can never be impeached if the words that they use would not be something that they could be criminally prosecuted for. I think there are a lot of things a president might say that would be so grossly inappropriate that they would be impeachable even without material consequences to them.
So I completely agree with that, and I think that's not only the most sensible way to think about impeachment. It's the way that we've thought about impeachment in the past, and because impeachment it's normally arises in a partisan context, it's always helpful if you have some precedent you can appeal to, showing some consensus across party lines. And we have that in this case because the articles of impeachment that the House Judiciary Committee adopted on a bipartisan vote, which never resulted in actual impeachment because Nixon resigned before that. But those articles of impeachment included charges having to do with things Nixon had said, things that may very well have been protected by the First Amendment if they were the subject of an ordinary criminal indictment. And I know, as far as I'm aware, nobody suggested at that point that there was some constitutional problem with impeaching Nixon on the basis of his words.
Some of our audience members are asking questions related to the question of precedent. And in this case, does this impeachment trial set a precedent that the Senate does not have jurisdiction to try an officer who's no longer in office? Does it set other precedents that might be worth teasing out?
My view is that it doesn't set a precedent that it would be unconstitutional. Enough senators voted that the trial could go forward, that I think that it sets a precedent in the other direction, even though some ultimately grounded their vote against conviction on the idea that it wasn't appropriate to try a former officer. So I think it doesn't set that precedent. I mean, I think that one precedent it does set, and this kind of goes to the difficulty of convicting, is that, it's going to be really unlikely. It's hard to imagine what kind of conduct is going to lead to a successful impeachment of a president in our incredibly partisan climate. So I think that's the precedent that I would sort of take out of it, which is not a legal precedent, but is more of a precedent sort of pragmatically. How much do people actually want to engage in impeachment proceedings that don't lead to removal from office or conviction?
So I think precedent is sort of important because, as David says, if when you can invoke precedents, especially bipartisan precedents, rare enough, right? You're on firmer ground, but there are plenty of issues that have been debated in impeachments and trials, all along. So take the issue of whether it has to be a criminal charge or even close to that. The first impeachment, the first successful impeachment leading to removal from a conviction and removal was of a federal judge for being drunk and insane. And in the Senate, one of his supporters said something like, there is nothing, almost a direct quote, there's nothing criminal about being insane. And yet he was convicted. And yet in many of the impeachment proceedings after that, the same argument was made, and nobody thought it was foreclosed by that result. And I suspect today, lots of us, maybe even myself, would say impeaching somebody for being insane is not appropriate. It's not a high crime or misdemeanor. It's not an abuse of office. So I don't know. I think precedents are extremely weak in this field.
Some in the audience express what I would characterize as some frustration with what they describe as the infuriating imposition of the wording of the Constitution, coupled with the two-thirds majority requirement, meaning that it's virtually impossible to convict a president, as you've pointed out. So perhaps this could get a little more into what Bernie alluded to in her remarks. What other purposes or functions should we understand impeachment as serving?
So I don't know. I mean, I think the two-thirds requirement is too high. I also think a bare majority vote to impeach is too high, because I think impeachment proceedings that are purely the product of one party are not good, and I think they tend to be just political theater. That was not true of this one. This was actually the most bipartisan, other than the Nixon proceeding. This is the most bipartisan proceeding in an impeachment. You couldn't say that for the first Trump impeachment, by the way, which was about the same. It might have been even more partisan than the Bill Clinton one. Two-thirds is probably too high, but that's what we're stuck with. And what I really think this shows is that our Constitution was actually not designed to be for such hyper-partisan circumstances as we now are in. That the fault may not be the two-thirds. The fault may be that folks are just so locked into the idea that they should support a president of their own party. And I don't know what to do about that. It would be nice if academics were more likely to cross party and take positions, but politicians are even less likely.
The difficulty of impeachment is one aspect of our presidential system, which is to say that we don't have a parliamentary system. There are a lot of countries in the world where if you lose majority support in the legislature, you're out. That we don't have that system. There are people who think we'd be better off with that system. I'm one of those people, but it's not the system we have.
Are there any reforms that are possible to the impeachment process that we have without throwing out our system and embracing a parliamentary one?
One thing that I thought was an interesting question that came up in the chat, but also just in the last few days, is whether the senators could decide to vote anonymously. I think, so they could change the rules and decide to vote anonymously. I think that there are other, recording requirements that might mean that if a fifth of senators decided that they wanted the vote to be public, it would have to be public. I think it would be interesting right now to have the Senate try to change the rules and make it a secret ballot, because I think, if you try to do it in the context of any particular impeachment, that would be implausible because of partisanship. But I think if they were to do it in advance, I think that would be a really interesting innovation. It certainly works, I think, pretty well in the jury system. So why not try it in the Senate? And then you wouldn't see people being so worried about the repercussions for their own reelection of voting to convict someone they think they should be convicting, and vice versa. You wouldn't see people who feel like they have to toe the party line and convict someone who they don't necessarily want to be convicting. So I think that might help eliminate some of the partisanship.
Well, the question is that constitutional? I think it might be a great suggestion, but the Article 1, Section 5, Clause 3 requires each house to keep a journal of its proceedings, etc., and the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal.
Yeah, so I think they'd have to, basically, you would have to ensure that fewer than 1/5 would disagree with the decision, right? Which maybe wouldn't be possible, but.
And it also doesn't sound like it's something that can be decided in advance behind the veil of ignorance. It sounds like it has to be decided in the heat of battle, which, as you say, is not going to happen.
I don't think that impeachment is an utterly useless mechanism, even if the likelihood of a conviction in the Senate is extraordinarily low. Presidents don't like to be impeached, and the threat of an impeachment, I think, is something that presidents bear in mind, and with some presidents, it may help to deter them from some conduct that we want them deterred from. I think this last impeachment trial I think it did serve some public benefits. I think it established an important public record. It communicated that record in a quite vivid way to lots of people. It allowed for airing of arguments about how we should think about appropriate presidential conduct and what kind of conduct should result in removal. So I think that we're probably better off for having gone through that trial than we would have been if the House just hadn't impeached.
How about censure? Would censure accomplish the same thing?
It might. I understand Speaker Pelosi's argument that censure seems too weak. It seems like too much of a slap on the wrist. But you could address that with some kind of super censure. So
maybe with a 2/3 requirement.
Yeah, I don't know.
I don't know. Censure is as powerful as we sort of make it as a culture. When Andrew Jackson was censured, and he was just utterly infuriated and after he then won re-election and his party took over Congress, they not only repealed the censure, but they actually voted to rip the pages out of the Congressional Globe, or whatever the record was called at that moment. They ripped out of the official journal of the Congress. So obviously Jackson cared about censure.
Yeah, I think one way to think about what happened in this impeachment trial is, why did it fail? When you had presidential behavior that was this egregious, so egregious that you had the most bipartisan vote for removal of a president in U.S. history, why did we still fall so far short? And I think that has something to do, it has a lot to do with where our politics are, and I don't think that's partly a matter of our political culture, but political culture is produced in part through institutions. And if what we want our institutions to be doing is to be furthering a kind of pluralist democracy in which people listen to each other and are required to take each other's views into account, and well, we don't have that kind of we don't have that kind of politics right now, and we don't have institutions that seem to be pushing towards that kind of politics.
An audience member asks, related to the issue of the function of impeachment. This person asks, without the impeachment power, would there have been any other way to force President Nixon's resignation?
Yeah, maybe, because Nixon was capable of shame. I mean, that's why he resigned before he was actually impeached. And when you have somebody who's capable of shame, you can use, there are a variety of levers you can use to try to shame them. I don't know if any of them would have worked as well as impeachment, but it's possible.
Well, the real difference with Nixon isn't that he had shame, it's that the leading members of his party in the Senate came to him and said that he was going to lose.
True, fair point.
A somewhat different aspect of the impeachment trial, one of our audience members asks whether Trump's lawyers crossed any ethical lines that could get them censured or disbarred. This person's curious about the senators meeting with the Trump legal team while they were also sitting as jurors, if there are any problems with that conduct.
I'm not an expert in legal ethics. If we're talking about their performance at the Senate trial, I don't see any ethical problem. Unless being really bad lawyers is now basis for disbarment. I wonder about some of the conduct of some of the lawyers outside of the during the month between, and I'm not referring to the bringing of cases. However, badly supported they were. I'm referring to some of the speeches that were made to crowds. I have to say, even if the evidence were stronger, I don't really approve of taking issues like this to the crowd. I think that if there are serious issues about an election, you document them, you take them to the proper authorities, and crowds should have nothing to do with it. The only effect of a crowd is going to be to intimidate, and that's not the way these things should be handled. And it could be that some of that was bad enough. I'm not sure.
We have another question going back to a prior theme about other ways to go about prosecuting former President Trump. What about charging him in DC under federal or DC law for disorderly conduct, for example?
Well, I mean, that's almost exactly the Terminiello case. And it's almost exactly the Terminiello case because Trump is almost Terminiello. I mean, they're so close in their rhetorical approaches and in their kind of odious hate mongering and racism. It's possible. I mean, you can read the Terminiello case as a case about pleading. And you can read the case to say that it would have been fine to convict Terminiello if he had been charged in a different way. But that's not the way in which the case is normally read. And the Brandenburg standard has generally been interpreted to place to require that the words call fairly directly and explicitly for violence. And it's just, I agree with Michael about this. There's a big difference under the First Amendment between a criminal prosecution and an impeachment. And I think that the First Amendment argument in the impeachment context was quite weak. But it's not weak at all in the context of a criminal prosecution, even a criminal prosecution for disorderly conduct.
I'd like to dissociate myself with the strong comparison between Trump and Terminiello. I think that's over the top. Terminiello was a much more odious figure. And I also do think it's an indictment of Mr. Trump for the events of January 6th in DC is unlikely to succeed, both because of the First Amendment issues under Brandenburg, but also because of the difficulties of proving intent. But there are other investigations elsewhere. I think the Georgia we don't know the facts there, so it's very hard to speculate, but there's some crimes defined by Georgia law having to do with trying to interfere with an election official's discharge of their duties. There may be charges having to do with misinformation to an official in connection with their duties and so forth. I'm certainly no expert in Georgia criminal law, but that'll be interesting. But most of all, I would say, I've been saying for a year now, watch Cyrus Vance in New York. And again, we don't know. The fact that there haven't been leaks is a great, my hat's off to the Manhattan District Attorney's Office. They are proceeding as things should, but I'm cynical enough about the way in which real estate is conducted in big cities like New York, and cynical enough, and I've heard rumors enough about how the Trump organization operates that it would not be surprising to me to find that that there are going to be some successful indictments there.
Another one of our audience members asks if the article of impeachment had been instead that President Trump had engaged in recklessness and negligence instead of incitement, would that have been a stronger case?
Well, I think they should have spoken of intimidation, which is also wrongful. It may not be as wrongful as incitement of violence, but it's certainly wrongful. And I don't see how anyone can doubt that what Mr. Trump did intentionally was an act of intimidation. You don't send crowds off to, pay a visit to decision makers at tea time just in order to engage in polite conversation. He wanted them to go there, and he wanted them to pressure the members of Congress to do things that other than what they conscientiously believe they should do. And that's also, very likely true of Mr. Raffensperger in Georgia and a couple of other folks in Georgia. Intimidation seems to me to be a more accurate description of the misconduct here than anything else. I wouldn't call it negligence strikes me as a very weird thing to charge.
Well, I think that actually is what Trump was charged with. Because in part, the article of impeachment charged that he willfully made statements that in context encouraged and foreseeably resulted in lawless action at the Capitol. And foreseeability is negligence language.
So since we are just about out of time, I want to offer each of the panelists an opportunity to provide some closing remarks that might help our audience, and in particular our students, sort of situate how to think about this unprecedented second impeachment of a president and the subsequent acquittal.
Well, I'll just reiterate what I said before, which is that I think that it's worth thinking about why this impeachment was unsuccessful, because I think that tells us some really important things about our politics and about that we need to address, and we need to address them on a number of dimensions. Some of it is cultural, but some of it may have to do with re-engineering institutions to drive our politics in more productive ways.
Yeah, I mean, I think I would just pick up on that by saying I agree with what Michael said earlier about the possibility that in this world of partisanship, impeachment isn't going to function adequately. And so I think it's worth thinking about, what are alternative mechanisms for constraining officers and in particular presidents apart from impeachment.
I'm not sure I have anything to add, except that I do think that it's important for all of us to police our own side with as much vigor as we do the other side. And that's not to say that Republicans are the ones who have to always roll over. It should be symmetrical.
Well, with that, I would extend my thanks to the panelists for convening on such short notice to talk about the end of this impeachment trial, which I really appreciate. I think this was a very illuminating conversation. And I just want to preview that the Constitutional Law Center will be holding another event this week. We have lots going on this week. We'll be meeting with former Senator and current ACS President Russ Feingold, having a conversation with Professor McConnell about bipartisanship this Thursday at 5 p.m. I think the registration link is in the chat field. So if you're interested, please do sign up and we hope to see you there.